Ready to go? All right, we have quorum. Yep. Okay, members, I detect a quorum. Civil full justice now in session. Clerk, call the roll, please.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan,
Here.
Chairman Carter. Mr. Vice Chairman, you have a quorum.
Thank you very much. Before we get started on our agenda, any announcements or personal orders? Seeing none, we can jump right into our calendar. Item number 1, House Bill 1252 by Chairman Faison. I've got a motion and a second. Chairman, you have the floor.
Thank you, Mr. Chairman. Committee, very good to be with y'all today. House Bill 1252, this bill is known as the Parental Life and Liberty Act. The bill is broken up into 2 parts. It prohibits civil causes of action for wrongful birth and wrongful life. It extends the wrongful death liability for the wrongful death of an unborn child all the way to conception. A wrongful life action is a civil claim brought on behalf of a child when the child is born with certain conditions where the child claims that it would have been preferable to have been aborted. The claim does not assert that the doctor caused the condition, but rather had a duty to inform the parents of the condition or likelihood that condition might exist, thus giving them a chance to abort. A wrongful birth claim is similar to the wrongful life claim, except the wrongful birth claim is brought by the parents rather than the child. Both wrongful birth and wrongful life claims are derived from the common law and not expressly mention the TCA, but rather they are left to judicial interpretation. This bill shall expressly prohibit these claims from being brought and thus makes a public policy statement that regardless of the medical condition, abortion is never a preferable state to life and should never be asserted in that way during a legal claim. These prohibitions do not preclude other garden variety medical malpractice claims where the doctor breaches his duty in failing to disclose medical conditions as long as the plaintiffs can prove damage other than abortion would have been more preferable. The other part of the bill addresses wrongful death claims for the pre-viability of unborn children. In Tennessee, someone who murders a woman or her unborn child can be charged and convicted of double homicide. However, the wrongful death civil claim, someone can only be sued civilly for the death of the woman, her unborn child, if the child is past the point of viability, which is around 24 weeks, when the child can survive out of the room. This bill allows wrongful death claims to be filed on behalf of the unborn child from conception to birth, so that the definition of human victim in the civil section of the TCA mirrors the criminal section.
Members, you heard the explanation. I think I'm going to kick it off here. Medical malpractice, I just want to make sure, and I want to give you a scenario to see if this would fall in here, and because of if a couple goes to the doctor, we have a hereditary gene, we want to be screened, and because we don't want to have our child to live that life of expense and that kind of thing. And the screening comes back, nope, good, it's negative, you're good to go, and the birth happens and then it's there. Would the couple be able to sue the doctor for medical malpractice and violating a standard of care?
Absolutely.
Okay.
Providing that you don't say, if I would have known, I would have aborted the child. Other lawsuits for medical malpractice are still, this bill wouldn't preclude any of that. Right. You just wouldn't be able to say, we are suing you based on the fact that we would have aborted this child had we known this.
Well, they made it up front. They said they're making their decision up front before conception or anything.
And if we pass this bill, it wouldn't matter. You wouldn't be able to sue the doctor solely on the fact that if you would have known something, you would have aborted the child. Now, it doesn't preclude anything else that if the doctor missed something, you couldn't sue them for that, for damages saying, I need help raising this child. But it would just say you couldn't use the fact we would have aborted this child had we known.
Okay. I'm going to open this up to questions. I may have another one in a minute or two, but Representative Stewart.
I don't think that's accurate. I want to make sure I understand the way I look at the bill. It's exactly what and it's a policy bill, and I understand it's brought in good faith with a particular perspective, but I believe the bill does say that in the instance that the chairman just brought up, this bill would eliminate a cause of action, because the whole idea of those subsequent expenses is that you would have been informed, and the answer is that there would be no damage claim based on that, right? That's what this bill does. It says in the circumstance the chairman just brought up, you cannot recover. Isn't that correct?
Oh, Chairman Faison.
The gentleman from Davids County, I would say that you, if we pass this and this becomes law, you could not sue based on wrongful life, saying because this life is here, it's wrong and we should not have had this life, and I'm going to sue you on that. It does not preclude you for suing any other negligence that the doctor did.
Chairman.
And I just, and I thank you for the frank answer. I think I listened very carefully to the question the chairman asked, and I understand, I think based on your answer, there would be no cause of action in that instance, because basically there'd be no cause of action for recovery of expenses going forward for that malpractice. Thank you, though.
Any further questions from members? Seeing none, we're going to be voting on House Bill 1252 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? No. Ayes have it.
Thank you, committee.
Move on to calendar and rules. Andy. Going out of session to give it to Vice Chairman Farmer, Chairman Farmer for a moment. I'll be right back.
All right, thank you, members and ladies and gentlemen. That brings us to item number 2, House Bill 187 by Chairman Keisling.
Motion on the bill.
You got a motion and a second, and you're properly recognized, sir. You may move forward.
Thank you, Mr. Chairman and committee. Last week's sub, I brought this to the fiscal note. The summary of the fiscal note, I might add, is spot on. It specifies that a local government entity will be immune from any liability for any cause of action or claim for damages arising out of a person's participation in privately appropriate licensed substance abuse treatment program approved by the court as an alternative facility. And what we have here is, actually this was brought to me by our former DA there in the 13th Judicial District, Mr. Randy York, whom many of you all know. And it states that in July of 19, we amended TCA 5510-402 to allow individuals who've been convicted of a DUI to serve their time in alternative facilities. And this legislation is asking that any government entity, which of course that's city or county, that would allow an individual to attend this type of facility within their jurisdiction be immune from any liability associated with such. Right now, currently, there are 2 of these facilities throughout the state. And so anyway, with that, Mr. Chairman, that I'll accept any questions that may be.
Thank you, Mr. Chairman. Members, do we have any
asked.
questions or comments for Chairman Keisling? Representative Clemens, you're recognized.
Thank you, Mr. Chairman. So I just want to make sure I'm clear. So if there's a substance abuse treatment program and it's renting a house in a neighborhood and individuals in that program do something, to cause a harm, the local government that licensed that is completely immune?
That's exactly what Mr. York brought. That's his intent with this, Representative. The program is called, which you all are very familiar with, and I don't mean to divert from your question. I mean, it's Prime for Life, and it's administered when, during their, while they're serving their required incarceration time. And yes, he says, and he states in his talking points here that, to his knowledge, there's not been any, nothing has led to this. There's not been any incidents in the past, but the city of Knoxville is considering one there, according to him. So they just wanted to feel better if we had some legislation.
Representative Clemens, any follow-up?
Yeah, thank you, Mr. Chairman. And I certainly, support the spirit of the legislation. We certainly don't need to do anything to deter from the use of these programs, and we certainly want to do everything we can to incentivize these types of facilities and reincorporate people back into the community. I just have a little concern about any unintended consequences of the legislation, because I think we've raised the issue in our subcommittee or even this committee before, maybe another, about how loosely regulated these entities are, and how little supervision. I know I've had some issues raised to me. So I guess I just am a little worried about the lack of regulation on the front end, but then the possible unintended consequences on the back end of complete immunity. So I appreciate the legislation. Certainly want to see more of these programs, but just have those concerns. Thanks.
Members, any additional questions? Chairman Kiesling, any follow-up? Good? Looks like it. Are we ready to vote? Any objection? Seeing none. We're voting to send House Bill 187 to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Bill moves on.
Thank you, Mr. Chairman and committee.
All right, thank you, sir. Brings us to item 3, House Bill 1126 by Vice Chair Russell. Second. Got a motion and a second. Sir, you're properly recognized there. Looks like we have 3 amendments here. So the first one I see is drafting code 4536. Representative Russell. Would you like to move forward on that, sir?
Thank you, Chairman. I was hoping to move forward on 006990.
Okay, so we do not need, you do not want to move forward on 4536?
That's correct.
Okay, so you're asking to move forward on 6990?
Yes, sir.
Very good. Members, we got a motion, we got a second, and you're properly recognized there.
Thank you, Mr. Chairman and committee. This bill is amended, defines the term seclusion as it relates to juvenile detention centers, youth development centers, and facilities where children are taken into custody prior to or after court rulings. The bill will fix a loophole that allowed juveniles to be placed in a segregated, confined setting for extended periods of time. It was not considered seclusion under the current law because they could hear and see others. The bill further clarifies that seclusion is not to be used for any reason other than a temporary response to behavior that threatens immediate harm to others. The amendment adds language to clarify that 2-hour period of seclusions may be reauthorized. However, no more than 6 total hours of seclusion within a 24-hour period will be allowed. The amendment also adds language stating that the department may, by rule or policy, provide alternative treatment options for a child who cannot safely rejoin the resident population following the maximum period of seclusion. Mr. Chairman, I renew my motion.
Let's go back in.
And I'll hand this back over to Vice Chair Jernigan, and we're on Amendment 6990, sir.
Thank you. 69. Have we adopted the amendment yet? Or okay. All right. All right. Any questions on the amendment? So let's put the amendment on the bill. We'll be putting, gosh, my glasses. Amendment 6990. All those in favor say aye. Aye. Those opposed, ayes have it. It's on the bill. We do have an untimely filed amendment from, got a motion and a second. We're going to vote on to put this amendment. Let's hear about the amendment first, Chair Lady. You recognize.
Thank you, Mr. Chairman. I'm going to withdraw that amendment.
Oh, to hear it? Oh, I'm sorry. All right, we need to vote on whether or not to hear the untimely amendment. All those in favor of hearing the untimely amendment, say aye. Oh, wait. Point of order?
Thank you, Mr. Chair. I think the chair lady said she was going to withdraw the amendment. Did I misunderstand that?
I've got, Chair Lady Littleton, you're recognized.
Yes, since it isn't owned, do I withdraw it, or what do I do?
I'm sorry, since you said. Chair Lady, do you want to run the amendment?
No.
Okay, if you want to run the amendment, then I would, yeah, we'll just move on. All right, we're going to, without objection, we're going to move on to, on the bill as amended. And so the amendment made the bill?
Yes, Chairman.
Okay, all right, so the amendment made the bill. So do we have any questions? Representative Griffin.
Thank you very much, Mr. Chairman. Thank you, sponsor, for bringing the legislation. I certainly share your concerns with the intent. I do have some reservations concerning the practical impact of the bill as amended. I've got a letter from the Council of Juvenile and Family Court Judges, Judge Irwin, who's the president of that council, and Judge Jackson, who's the legislative chair, that they said that they expressed the following concerns about the current amendment and its limitations on the discretion of a facility to utilize seclusion in the following appropriate circumstances: the need for seclusion where a child is in danger to self or others, the need for seclusion to prevent rival gang violence, and the need to utilize seclusion in exigent circumstances for more than 2 hours. So do you know, does this amendment you've got, has it addressed those concerns of this august organization that deals with juvenile court issues day in and day out?
Thank you, Mr. Chairman. We have addressed that and added 2 additional periods of seclusion, which was, of course, a total of 6 hours total within a 24-hour time period. And then if they need to go beyond that, the department may, by rule or policy, provide alternative treatment options for a child who cannot safely rejoin the residential population following the maximum period of seclusion. So we addressed that with this new amendment.
Thank you.
Thank you. Got a question on the bill. All those in favor of sending House Bill 1126 to calendar and rules, say aye. Aye. Those opposed? Ayes have it. Off to calendar and rules. Then stick right there. We got item number 4, House Bill 697. Got a motion and a second. It's before us, and you have an amendment, sir, 6614?
Yes, Chairman.
Got a motion and a second on the amendment, 6614. We're going to put that amendment on the bill. All those in favor, say aye. Those opposed, ayes have it. Chairman, let's hear your bill as amended.
Thank you, Mr. Chairman and committee. The bill, the amendment makes the bill as amended. House Bill 697 will draw certain 501c4s into the Governmental Tort Liability Act if they provide functions and services traditionally provided by municipalities. 501c4s would need to meet the following criteria to be eligible under this bill. They must maintain more than 100 miles of road, own or operate a water or sewer distribution service, appropriate funds to support a nonprofit volunteer fire department, or appropriated funds to support a police department, manage trash pickup services, and fund, operate, and maintain at least one park, recreational facility, walking trail, and dog park. Be designated as a census-designated place as of 2010 census. There are only 2 entities in the state of Tennessee that would fit this definition, and that's Fairfield Glades in Speaker Sexton's district and Tellico Village in my district. Both of these entities consist of thousands of acres and close to 10,000 residents each, which makes them larger than some cities across our state. This bill will give these entities the same protections of the Governmental Tort Liability Act, including tort liability caps and immunity from suit, except as outlined by state law. Mr. Chairman, I renew my motion.
Thank you, Chairman. Representative Stewart.
It strikes me as a very significant change in our law. Tellico Village, I'm not as familiar with Fairfield Glade, but Tellico Village has been around since I was in school. You know, right now and for many decades, they're just like every other homeowners association. If they build a bridge and it falls out and a family gets killed or injured, they recover just like people do against any entity. Why would we want to now essentially make them immune from suit using the Government Tort Liability Act, which is designed to protect governments that we all need, you know, over time? We can't recognize that governments are a special entity responsible to the taxpayers. Why would we want for the first time to extend this extensive liability protection to these private enterprises?
Sure.
Thank you for that question. And this is something that they're so close to a government entity already, and this will just expand that. And this is not unheard of. There's already 3 501c4s that are already doing this, and this would just include that to make them the 4th and 5th ones.
Stuart?
Thank you, Mr. Chairman. Yeah, I guess I think this goes down a very dangerous road. It's easy to pass these non-liability bills because it passes, nothing happens, and we don't worry about it until somebody's pregnant wife slips because of negligence of the community, is severely injured, a child is injured, and now somebody has to pay millions of dollars of bills, and it turns out because of this act today, it's the family that's going to go bankrupt instead of the association or what have you. I think it's a very dangerous road. I understand you're bringing it with a good intent. I thought your last bill was fantastic, but I think this is a problem. It turns out apparently you're saying that there's some precedent for this. I don't think we should be extending tort liability protections that are not given to most private enterprises to non-governmental entities like this. I think it's very concerning. Thank you.
Thank you.
Representative Smith?
Thank you, Mr. Chairman. And I wanted to follow up. What is the precedent on this? Because I'm thinking that this could actually assist in some of the opportunities that we have to expand retirement homes and villages as they were. But if you could offer what precedent is there? Is there another application in the state of Tennessee to something similar? Thank you, Mr. Chairman.
Jeremy?
So thank you for the question. As I said before, there's 3 others, and this will be the 4th and the 5th. And they would have to meet certain requirements to fall under this category, and that would be in statute.
Representative Griffey?
Thank you, Mr. Chairman. How long ago were the other 3 associations given this protection? Do you know?
I don't have that information right off the top of my head.
Are they all homeowners? I'm sorry.
Go ahead.
They're all homeowners associations?
There's a park in Shelby County and 2 hospitals.
So this would be the first private homeowners association that we'd be extending this to?
First 2.
So it'll be 2?
Yes, sir.
Mr. Chairman and members, I'm just concerned, as my friend down there from Davidson County's indicated, this could be opening up a slippery slope. And look, I have no problems if we want to address liability issues concerning claims that are brought against private entities or public entities. My concern here is the Governmental Tort Liability Act was specifically set up to protect governments and municipal organizations because it's the taxpayers' dollars that were at risk. And private entities, even if they're nonprofit, they're made up of a collection of folks, and they contribute through fees and so forth. So I'm just concerned that if we do this time, we'll have another one, somebody else. And I'd rather keep the 2 animals separated. And if we need to address liability issue for homeowners associations, I would argue we should just take that up separately. So thank you. Those are my thoughts.
Any more questions? Curcio, thank you.
Thank you, Mr. Chairman. And I just want to thank the sponsor for bringing the bill. I think you've done a great job tightening this up. I know you had some questions early on, and we worked those in the subcommittee, pretty hard before you even brought the bill up. And, one of the things, and I understand this kind of argument around mission creep, I certainly understand that, but adding the section you did about, as a census designated place according to the 2010 federal census, I think that helps a lot. I think the dog park, the trash pickup, the volunteer fire department, I mean, these The two entities you're talking about, if I'm not mistaken, would probably be just as happy to incorporate this, just that they may not be able to do that. Is that accurate, or?
That's correct.
Okay, all right. So I just want to thank you. I understand we want to be cautious about extending, governmental tort liability to non-governmental entities, but I think these are ones that really walk and talk like ducks, and we're just asking them to be treated like a duck. So I appreciate the legislation.
Thank you.
Representative Griffey, follow up?
Thank you. I was sitting here thinking and wondering why this homeowners association just doesn't incorporate become a municipality or something like that. Is there a problem with the county commission, a dispute there or something? They don't want to approve it or something?
So is Matt Russell on the testimony list today? If not, I can.
He is not.
Okay. So from my understanding, and I hope I get this right, there's so much involved in where of this paperwork or however it's done, they just couldn't get it legitimately figured out how to do it, I guess, but I'm not sure. I thought he was on the list.
Representative?
I'm not sure how to respond to that, but I would think there's a legal process to do it, and they ought to be able to follow that legal process. And if there's a political dispute between the county commission and this homeowners association they want to block it for whatever reasons, I'm hesitant to involve the Tennessee General Assembly in that county dispute, and I would oppose it on that basis as well, so.
Sure.
I necessarily don't know that there's a county dispute. I know there was an issue with they'd had to pay something like 15 years of back taxes or something like that. It was just so much amount of money that it just didn't make sense for them to do that. And then I think the county commission also has to approve it, but I don't know about any kind of dispute.
Representative Garrett?
Thank you, Mr. Chairman. Representative Ruff, thank you. I think privately expressed a lot of concerns that on the bill that's been talked about today, and you were more than willing to kind of help narrow that list. I think you listed 5 or 6 factors that the 501c4 has to qualify, and those are all factors. They're not, you just don't use one of them and you can grab this government tort liability protection. You have to have all of those. And so I say that, and maybe this is more of a comment, but maybe you can confirm, to your knowledge, there's no other 2 places similar like this in this state that's even close to meeting those 5 factors under this statute whatsoever. That's my understanding, but I just want to make sure that from your perspective that there's no other locality in this state that has come close to reaching those 5 factors under the statute that you listed, that they would then be subject under the Government Tort Liability Act. Is that accurate?
Chairman?
That is correct. We want to make it pretty specific where that's the only 2.
Thank you.
Representative Clemens?
Thank you, Mr. Chairman. Question, do the 100 miles of roadway and all these other factors, do those roadway have to be contiguous?
I don't know.
And so it's feasible, you could have one entity set up for multiple projects around the state of Tennessee that cumulatively would add up to satisfy this under 1C4. So that raises a whole other can of worms for me, the fact that it doesn't specify that. So thank you.
Chairman. Representative Bricken?
Thank you, Mr. Chairman. I just want to kind of clarify something. I remember when this bill was being talked about, one of the other reasons why Tellico Village cannot incorporate as a city is their proximity to the city of Loudoun and Lenore City, because those 2 cities would also have to approve their chartering along with the county commission. So just for clarification.
That is correct.
All right, thank you. Question's being called without objection. We'll be voting on House Bill 697 to go to calendar and rules. All those in favor say aye.
Aye.
Those opposed? Nay. The ayes have it. Oops, moves on to calendar and rules.
Thank you.
All right. Item number 5, House Bill 1200 by Chairman Hawk. Do I have a motion? Got a motion and a second. Chairman Hawk, you've got an amendment, 5388. Got a motion and a second on amendment 5388. Does it make the bill?
Yes, it does, Chairman and members.
Since it made the bill, let's go ahead and put that on the bill. All those in favor of putting amendment 5388 on the bill, say aye. Those opposed, ayes have it. Chairman Hawk, your bill is amended, sir.
Thank you, Mr. Chairman. In explanation of the legislation, House Bill 1200 will assist the conversation about justice reform. In order to do this, we must have a workable system of data sharing. What this bill does, it will require the Administrative Office of Courts to provide each court clerk in a county that has not installed the Tensis system with a list of data that is required to be integrated with Tensis under Rule 11 of the Rules of the Supreme Court of Tennessee or the state law. So this is going to become a data sharing that's going to get us on the same page in terms of what one court does from the next to the next to the next, Mr. Chairman and members.
Okay, you heard the explanation. Representative Parkinson.
Thank you, Mr. Chair, and thank you, Chairman, for bringing this bill. Sometimes I just feel like we're stuck in the Stone Ages when it comes to sharing information. A couple of questions. Is there a fiscal note tied to this for them to start lining up the systems and everything?
Thank you, Chairman. There is not.
Okay, and which is great. Thank you for that. Now, the other question is, with this information that's being shared, is this only through the courts, or is this throughout law enforcement and other entities that are involved in that process also?
Thank you, Chairman. At this moment, it is through the courts.
Okay. Thank you, Mr. Chair, and thank you, Mr. Chairman. One last question. Would the information that's being shared through the courts also share information in regards to asset forfeiture?
Chairman.
Thank you, Chairman. I do not have an answer to that. That is not a question or a concept that has come up in discussion of this particular legislation. I don't know the parameters of that, how it would fit in this data sharing. So I do not have an answer for you.
Okay. And just one last, and thank you for that. But so the information that will be shared will be criminal information and civil information?
The information is going to be shared from our court clerks. So if there's a court of civil action, then it would be shared there as well as the criminal information.
Okay, thank you for that. It's a good bill. Thank you for it. Appreciate it. And actually, I want to sign on to it too.
Thank you.
Okay, any further questions? Seeing none. The question has been called without objection. We're voting on House Bill 1200 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it.
Thank you, Chairman and members.
All right. Thank you, Chairman. On the item number 6, House Bill 1377 by Chairman Crawford, who just waltzed right in on time.
Thank you, Mr. Chairman. Thank you, committee. Today, I have House Bill 1377 before you.
Chairman, we got an amendment, 6702.
Correct?
Got a motion and a second. Does it make the bill?
No, sir.
Okay, let's hear the amendment.
It's a small change, but it's a very big change. It changes the word from shall to should, and that's does away with the $9 million fiscal note that we have on there. So, like I said, very small but very big.
I think that probably does rewrite the bill. So I'm going to let's put that on the bill, the amendment on the bill. We're voting on Amendment 6702 to go on the bill. All those in favor say aye. Those opposed, ayes have it. Chairman, your bill as amended.
Thank you, sir. And committee, this bill is known as Eli's Law. We brought this last year and got through the House, but due to COVID, it did not get up to be taken up in the Senate. I don't know if you're familiar with the nonprofit organization Isaiah House 117, but this is a program that was started by a young lady that dealt with foster children on the day that they were removed from their parents, foster parents. And it's just a very trying time for those individuals. And they've created a house called Isaiah House to take the kids there. They can play video games, they can get counseling, they can talk to people if they need to. So that's where this stemmed from. Basically, what this law does is if a child has been removed for neglect or violence or something from a foster parent, and then that parent becomes expecting, has another child, then this will make the judges aware of that, so they can go back and check on the new child to make sure that it is being taken care of properly. And if not, then it gives them the option of dealing with it how the judge wants to deal with it, as far as taking that child into, Child Protective Services or a nonprofit or those type things. But that's what the bill does.
Okay. Members, you heard the explanations. Chair Lady Littleton.
Thank you, Mr. Chairman. I do thank you for bringing this. I've worked on this since I've been here, and so you found a way to do something in a roundabout way that I could never accomplish, so thank you very much. And we all have families like this, and all we're doing is looking out for the best interest of a newborn child. Thank you.
Absolutely.
Yep, Chair.
Thank you, Mr. Chairman. Thank you, Chair Lady Littleton. I do know that you worked on it a lot, and I would love to stand here and take credit for that little word that took $9 million off the fiscal note, but that was done in the Senate, and so I'd love to take credit, but I can't. I'm just a part of it, so.
Ferguson.
See that, Mr. Chair, I wasn't gonna say anything until you said that part, so you're making it look like the Senate is smarter over there, so be careful, man, easy now.
I'm sorry.
Yeah, but this is a great bill, man. Thank you for bringing it.
Thank you.
Okay, seeing no further questions, we're going to be voting on House Bill 1377 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it. You're off, sir.
Thank you, Mr. Chairman. Thank you, committee members.
All right. Item number 7, is House Bill 798 by Representative Chisholm. Got a motion and a second. Representative Chisholm, you have an amendment 6201, is that correct?
That would be correct.
All right, I got a motion and a second on the amendment. Did the amendment make the bill?
The amendment makes the bill.
Okay, we're going to put this on the bill and then go from there. We're voting on Amendment 6201 to go on the bill. All those in favor say aye. Those opposed, ayes have it. We are now on the bill as amended. Representative Chisholm, you have the
All
floor.
right. Well, this bill limits to 4 years the amount of time after the completion of an improvement to a street, a sidewalk, or a highway that a claim can be brought against a local government to recover damages associated with injuries or wrongful death, which occurs from the deficiency in design, planning, supervision, observation, or construction of an improvement. I have Mike Fletcher here for any detailed questions you may have, but with that, I renew my motion.
Okay, members, you heard the explanation. Any questions? Questions been called. We're going to be voting on House Bill 798 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it. Calendar
Thank you,
rules.
Chair and committee.
Okay. We are at item number 8, House Bill 1547. Representative Weaver. Here she is. You have an amendment 6387. Okay, 637. Okay, I got a motion and a second. Representative, does it make the bill? Or
6387 is, yes, it does.
okay, let's go ahead and put that on the bill. Be voting on amendment 6387. All those in favor say aye. Those opposed, ayes have it. Representative Weaver, we are on the bill as amended.
Thank you. Thank you, Chairman. Thank you, members. Earlier this year, Governor Bill made a comment that it is going to take all of Tennessee to make our state a national leader in foster care and adoption. And so what House Bill 1547 seeks to do as amended will move the needle so that children 18 months and older can now be placed with families who have exemptions, and thus make more children having the opportunity to experience a thriving environment, a loving and secure home that every child certainly deserves. And that's what this bill seeks to do.
Members, you've heard the explanation. Any questions? Seeing none, we're voting on House Bill 1547 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it. Off to calendar and rules. Stay right there.
Thank you so much.
House Bill, oh, I'm sorry. I thought it said Weaver. I got my glasses on. All right, you can go, Representative Weaver. Okay, House Bill 446, Representative Warner. There he is. Got a motion and the seconds before us. We do have an amendment, 5790. Is that correct?
Thank you, Mr. Chairman and committee. Yes, that's correct.
Okay. All right, we have a motion and a second on that. Does it make the bill, sir?
Yes, sir.
Okay. We're going to put this on the bill. We're voting on Amendment 5790 to go on the bill. All those in favor say aye. Those opposed, ayes have it. Representative Warner Weir on the bill as amended.
Thank you, Mr. Chairman. House Bill 446, known as the Tennessee Firearms Protection Act. What this bill does, it will stop the use of state or local funds or employees to enforce any federal law or executive order regulating the sale of firearms, ammunition, or firearm accessories if they violate state law or the state constitution. I renew my motion, Mr. Chairman.
Thank you. Members, you heard the explanation. I think, just to clarify that this current law, the only thing really changing is the word sale. Is that right?
That and the amendment adds that an entity that may move against this bill could lose funding following fiscal year.
Okay. All right. Seeing no questions, we're going to be voting on House Bill 446 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it. Off calendar and rules.
Thank you, Mr. Chairman. Thank you, committee.
Okay, House Bill, item number 10, House Bill 1254. Representative Sexton, there he is. Sir, you've got an amendment 6534, is that correct? Oh, a motion on the amendment? Got a motion and a second on the amendment, make the bill?
Yes.
Okay, we're going to put this on the bill. All those in favor of putting 6534 on the bill say aye. Aye. All those opposed, ayes have it. Representative Sexton, we are on your bill as amended.
Thank you, Chairman and committee. What this amendment does, it deals with nothing more than the amount of money that attorney can collect in a civil asset forfeiture. Right now, the limit is $3,000. That $3,000 is based on the evaluation of two different things. One, the amount of money that's seized. For instance, if they get $2,200, which is the average amount that's seized in cash, it's only 25% of that. So the only amount that an attorney could receive is the most is $550. If it goes to the assets, such as a car, personal items, it's 25% of whatever the book wholesale value is. If it's a $4,000 car, then it would be 25% of that, which would be $1,000. What this does, it does away with the actual valuation of seized property. It goes only to the amount of money or expenses that the attorney is out, his hours and his expenses. Cannot exceed $10,000, but it has to be documented, has to be approved by the judge. So it does away with the $3,000 cap, does away with the valuation, and it just goes to the actual amount of time that the attorney, time and expenses that the attorney has accrued in the case itself. The reason for this is many times in these civil asset forfeitures, they have such a small amount, and the attorneys themselves just, it's not worth them fooling with. And so many times the citizens are just left with no asset or no way to really claim a small amount of money back. And I had a personal constituent. It was a 78-year-old woman and her 80-year-old husband that had all of their guns seized and kept them for 4 years and never moved in the courts, and she had no means of getting them back, and she and her husband, of course. But when I got involved, it took me 2 years, but I finally was able to get them to give them our guns back. Went to trial. There was no warrant served or anything, but they continued to hold their guns. So this is just a means
to help, the individuals be able to retain an attorney and the attorney to get the amount of time that they really need to be able to help them. So I think it's a good bill, but I'd be glad to introduce or to entertain any questions.
All right, thank you. You've heard the explanation. Representative Griffin.
Thank you very much, Mr. Chairman, and thank you, Chairman, for bringing this legislation. I applaud you for doing it, not because of it'll help attorneys, but what it's going to do is help balance those scales out for the people that are at the very bottom and don't have assets and resources to be able to fight an attorney who's on the other side of these asset forfeiture things. They're left with no hope, essentially, and they're often, it's better for them just to walk away. And that's not right. And so I applaud you for bringing this. If you want to bring legislation next year that we would turn these asset forfeiture cases and make them go through General Sessions Court, I would highly support that, because we don't need a Department of Safety, in my opinion, making the decision on these cases. I know they have ALJs that do those things, but I like having elected judges be the decision trier of fact on these cases, and I support this bill and support any efforts along those lines. Thank you.
Chairman.
I'd just like to say that that is exactly why that I brought this, was because those on the lower end of these assets, they can't get any help. And you're exactly right. That's what this bill does.
Chairman Bricken.
Thank you, Mr. Chairman. I certainly like the legislation, but I have a kind of just a general question, being not an attorney, but I'm just surprised that we have a limited, a statute that limits a plaintiff's ability to pay an attorney any amount if they want to seek justice. And so it's just a general question. Is this common, or do we have this in other areas of the law that we limit the attorney fees?
I'm not an attorney, so we'd have to ask an attorney. I think that they could pay them any amount that they wanted to. The problem is that the seized amount is so low that in many cases it's not worth their own money of trying to get it back. So if the courts say that they were seized unlawfully, or they're not convicted of a crime, they have to spend so much money on it, it's normally not worth them getting it back, because the average is $2,200. That's what the average seized amount is. So yeah, they could pay any amount they want to, but as far as them getting reimbursed through the courts, that's where the limit is, yes.
That's true. Is that good enough? Yeah, okay, that was good. Let's check with legal. You're accurate. Good job. Any further questions? Oh, Representative Garrett, you have a question?
Thank you, Chairman Chesney, for bringing this legislation. I remember I brought a similar amendment to some legislation that was passing through the legislature last time, and actually I would prefer, like Representative Bricken said, there'd be no cap. There'd be actually attorney's fees incurred would be the standard for someone to get paid back. But I do want to just clarify one thing. While I believe you're absolutely correct about the average being seized is 2,200, that's very hard to average if you've got a full 18-wheeler full of cocaine to say that that would be the average seized when we're probably talking about, I believe that's a reference into cash. So I don't certainly want to, I just want to make sure it's not just cash we're talking about that we're getting off the road. So on the flip side of this, I 100% support the ability of our police officers to seize drug traffickers, et cetera. But also the person that does get, like your particular constituent that has a problem, that is outrageous, in my opinion, if there is a situation like that you described that wants a lawyer. I don't do any of this work whatsoever. Never had a case come through my door about retrieving someone's asset that's been taken by the government. That would be a daunting task. Certainly someone would expend more than $3,000, which in my opinion is a ridiculous amount, for a cost to come to court to interact with our judicial system. So I applaud this bill. I support it. I'm going to vote in favor of it. I hope one day we don't need a cap whatsoever. So thank you for bringing the legislation. I appreciate that.
Any further? Oh, Chairman, go ahead.
I just wanted to verify that I appreciate Chairman Garrett bringing that out because he is correct, and I should have clarified that. It's cash, $2,200 cash. It's not if they've got $1 million worth of drugs. It's just the average amount of cash that is seized is $2,200. So appreciate you bringing that out. I also would have liked to not seen a cap on it. We worked with the departments, and this is where we felt like that we could get to at this time. Hopefully, you know, it will be an endless cap because I think that's what's fair. But this is where we could get to and working with everyone, and so we agreed on this.
All right, it's a good first step. Any further questions? Seeing none, we're going to vote on House Bill 1254 to go to calendar and rules. All those in favor say aye. Aye. Those opposed, ayes have it. Calendar and rules.
Thank you, Chairman. Thank you, committee.
Yes, sir. On to item 11, House Bill 1072. Chairman Curcio, you have a first and a second. So Amendment 6767, is that correct?
Thank you, Mr. Chairman. Thank you, committee.
Is that correct?
Yes, sir, 6767.
Okay, makes the bill?
Yes, sir, it does
All
make the
right,
bill.
we're going to put that on the bill. Putting Amendment 6767 on the bill. All those in favor say aye.
Aye.
Those opposed, ayes have it. Chairman Curcio, on the bill as amended.
Thank you, Mr. Chairman. This bill seeks to, apologize, I'm trying to use my iPad, and it is being slow. That's what I get for trying to use the technology. House Bill 1072 as amended seeks to ensure that the laws passed by the General Assembly remain in effect until a final determination as to their constitutionality has been made. The laws we passed are presumed to be constitutional unless a court finds otherwise. Unfortunately, the recent history has shown that such rulings have often been overturned by the Court of Appeals or the Supreme Court. Just because one judge in one part of the state believes one of our laws to be unconstitutional does not mean that a judicial panel representing one of our grand divisions or a court representing the entire state will agree. With that track record in mind, I would argue that it is prudent to stay any injunction from a trial court concerning the constitutionality of state law until we see the outcome of the final appeal. There is no need to unnecessarily block our laws from going into effect if they are eventually going to be confirmed as constitutional. This legislation seeks to do just that. I'd be happy to answer any questions.
I've got Representative Clemens.
Thank you, Mr. Chairman, and Mr. Representative Curcio, we discussed this quite at length in the subcommittee, and so I just wanted to go over some of those questions and add some others, if you don't mind. Again, the very purpose for an injunction is to prevent irreparable harm or other numerous circumstances that is even required to meet the threshold for injunctive relief at the trial court level. Are you not afraid that the state will simply file an interlocutory appeal in every instance simply to defeat the purpose for the injunctive relief being granted at the trial court level?
I couldn't seek to predict that. No.
Well,
Representative.
thank you. Well, do you have any concerns about the state abusing this law for purposes of defeating the purpose for injunctive relief at the trial court level?
I think if a lawyer did that intentionally, it'd be against their ethical rules of conduct, just using that as a tactic, but I'm not sure about that, but I think that would be.
Well, may I?
Yeah.
Thank you, Mr. Chairman. Well, I disagree with you. I think every litigant has the ability to at least apply for an appeal, but you're creating a law that gives them that appeal as of right. So by definition, under the verbatim language of this bill, you're creating a de facto right for them to take that appeal. And so that in itself would defeat the purpose for injunctive relief at the outset and defeat the very purpose for it in the law that exists today. So moving on, unless you have a response, do you have a response to that?
Thank you, Mr. Chairman. I didn't hear a question, but
okay,
continue.
I just want to make sure.
You have a separate question?
Before I change the subject, I just wanted to give an opportunity to respond.
Oh, okay.
So, thank you, Mr. Chairman. So, we have Rule 9. We discussed that last week. Interlocutory appeal by permission from the trial court and even the appellate court. So that rule exists today, and now you're seeking to create an absolute right that abolishes the very purpose for injunctive relief at the trial court level and the trial court's discretion, overstepping their authority here. So why, because we already have Rule 9, why would you want to create this, put this in the law? It seems to be somewhat redundant.
Thank you, Mr. Chairman. I mean, I think I stated that in my initial remarks.
Well, you said,
Representative.
yeah, thank you, Mr. Let me ask it this way. So in your remarks, you said due to recent history. So I'm assuming you're referring to the absentee voting case, correct me if I'm wrong, and other cases, I guess, that the state has lost recently. So, you know, in that instance, in the voting case, for instance, injunctive relief was granted to protect the rights of voters. Why would you want to defeat that and pass a law that is redundant to Rule 9? The state had the opportunity to appeal that.
Thank you, Mr. Chairman. Yeah, so, I mean, that's a great example. What we want to make sure is that we don't have this kind of stop and start, right? So until the ultimate appeal, you know, takes place, we want our law, which we pass, which is presumed to be constitutional, to stay in force for clarity, if nothing else.
Okay, I'm not trying to have a running dialogue. I'm going to ask distinct questions. I apologize, Mr. Chairman.
All right.
Okay, so, and I think you limited this in your bill to specific types of cases that challenge the constitutionality of a state statute. And so that's an extraordinary type of case. Would you agree?
Chairman.
Yes, sir.
So, okay, then that leads me to Rule 10 that's already in the books, which is extraordinary appeal by permission on original application in the appellate court. That rule in itself seeks to address extreme types of cases, not just specific in, you know, with regards to a voting rights case, but that gives a litigant protection if a judge has so departed from the accepted and usual course of judicial proceedings as to require immediate review. There again, we have a rule in the books that seeks to accomplish precisely what you're seeking to accomplish. So even with Rule 10, why do we need this legislation?
Chairman.
Thank you, Mr. Chairman. I would just thank you for the endorsement of this legislation. It sounds like it meets up with the rules.
Representative.
Thank you, Mr. Chairman.
End this up. Go ahead.
Well, I would respectfully disagree because Rule 10's extraordinary appeal allows the Court of Appeals to take this up if the lower court has so far departed from the accepted and usual course of judicial proceedings as to require immediate review, or if necessary for complete determination of the action on appeal as otherwise provided in the rules. So that is interesting because you cited recent cases. In recent cases, even the one that you cited, the state did not seek Rule 10 appeal. And that's telling. The state had access to this rule. So the precise case that you're using as a basis for this legislation, this rule was not even relied upon by the state or sought to be used to stay that injunction or any other relief.
Thank you, Mr. Chairman, and I appreciate that. I just want to be clarified. I haven't referenced a specific case, but I just for the record, just folks watching at home, this is not targeting a specific case. So,
well,
but thank you.
Representative.
Thank you, Mr. Chairman. I appreciate the long leash. Just one more point here.
No,
well, you said recent cases. So
Representative Stewart's next, and we can come back later if it comes to it. But let me get Representative Stewart first.
May I ask one more question on that point? It's Mr. Chairman.
One more. That's it.
Well, recent cases was cited. In the past year, Rule 10 has not been used one time to appeal a case from the Davidson County Chancery Court on these specific types of cases. That is telling, because if this bill was necessary, there would be a litany of cases seeking to use Rule 10. They have not used that. So that's my point. Thank you, Mr. Chairman. You already recognized Mike.
I've got a question and a second on the bill. I have an objection. 1, 2, 3. So we're going to vote on the question in the bill.
You already recognized him.
All those in favor of the question in the bill say aye. Those opposed?
No.
The ayes have it. we're going to be voting on item 11, House Bill 1072, as amended to go to calendar and rules. All those in favor say aye.
Aye.
Those opposed? Ayes have it.
Thank you, Mr. Chairman. Thank you,
Item number
committee.
12, House Bill 1268. By Chairlady Littleton, and Chairlady, you have an amendment as well?
And it does make the bill, and it's 6241.
Okay, I've got a motion and a second on the amendment. We're going to put that on the bill. Okay, all those in favor of putting 6241 on the bill, say aye. Those opposed, ayes have it. Chairlady Littleton, your bill is amended.
Thank you, Mr. Chairman. This bill says that the Department of Children's Services shall notify the appropriate court when the department has knowledge that a foster parent from a kinship placement violated a court order by allowing a child to visit the child's parents within 30 calendar days of the department's knowledge of the information. We're finding that a lot of the kinship, when the parents come back around and have not completed their recovery or their parenting classes and are supposed to be on supervised visitation, that these foster parents of kinship are giving the parents back the child, and then they just start the cycle all over again. So that's what this bill does.
Members, you heard the explanation. Any questions? Seeing none, we're going to be voting on House Bill 1268 to go to calendar and rules. All those in favor say aye. Those opposed, ayes have it.
Thank you, Mr. Chairman and Committee.
Yes, ma'am. So, members, that takes us to the end of our calendar. Are there any personal orders before we adjourn? I will entertain a motion to adjourn. All right, so moved.